Hi, I'm Jennifer Brown, editor of Canadian Lawyer In-House, and I'm joined today by Scott Fairley and Ian Mitchell of Weirfolds LLP. In this edition of the Weirfolds Quiz, we're looking at a particularly new species of tort liability that may be applicable to Canadian oil and gas and mining companies that may be doing work in potentially hazardous jurisdictions abroad. Scott, there's a lot of publicity around a Canadian company that has a number of lawsuits against it pending in Ontario court involving work that took place in Guatemala involving Indigenous people. Is that the kind of liability that we're talking about?
Yes, exactly, Jennifer. The case you're referring to, or multiple cases, are called Chalk versus Hud Bay, and it hit the news as a relatively groundbreaking piece of litigation, not only because it was reaching out to conduct that didn't have much, if any, connection to Canada, but because of the kind of law that was being brought into play. Hud Bay was in an unenviable situation of taking on the liabilities of a company that it purchased, and so the conduct that's being targeted is, as far as they're concerned, in the past. But there's some pretty serious allegations which feed off of international legal obligations that Canada has acquired through the ratification of major human rights treaties. And those treaties, those treaty rules, have found their way into the common law as so-called customary international law, which the Supreme Court of Canada has said in a case called Hape versus the Queen a few years ago, are part of the law of Canada unless there's explicit statutory exemptions to the contrary. So this is essentially a new species of liability in that the alleged torts are really based on various rules and principles of international human rights law, as distinguished from the traditional common law of negligence. So what's going to happen in the Hud Bay case is whatever facts are proven in court will then be measured against this new body of law. So from that point of view, it is essentially a new species of tort law that we're looking at, and is particularly relevant for this community because Toronto is so prominent in the financing of resource companies all over the world.
Ian, what can Canadian companies do to mitigate the risk of these kinds of cases?
Well, Jennifer, perhaps not unsurprisingly, there's no easy answer to that question. But what companies can and should do is instill a top-down culture that clearly demonstrates respect for human rights. This can be accomplished in a number of different ways, including good policies and procedures, effective training, and targeted performance and other assessment metrics. Companies also need to pay attention to the practical side of it and make sure that they make these policies and procedures available in the local languages. There may be more than one depending on the jurisdiction, and provide training not only to employees but also to third-party service providers so that everyone working for that company knows what acceptable behaviors are. There's also no one-size-fits-all solution, so companies need to consider their response to this new and developing area sort of in the context of the nature and extent of their operations in the foreign jurisdiction, so that is proportionate. And finally, the board should always be vested with oversight of this issue, not only so that they can assess the risk that Scott was just talking about, but also so that they can back up that top-down culture that I was talking about earlier.
Okay, thank you very much. For a more in-depth look at this and other issues around tort liability, please see the December issue of Canadian Lawyer In-House and read the full quiz.